Chris. Ok, voy. Hang on a second. Volume is on. Okay. Are they talking? No, I don't hear anybody. Participants 18. I guess not your turn yet, this one.
Mr. Christopher, it's working for you. Everybody else is just muted.
Oh, sorry, I just got the volume.
No worries, you're good. It's working for you though.
Yes, sir. Which page are we supposed to be on? I don't know, but now the volume's gone again. Luis Garcia, look for Luis Garcia. Luis, no.
Morning.
Mr. Sorolla.
No, guess not there. Norma, Lily just sent me a message saying Brittany Roxanne Williams will be reset to plea on a misdemeanor.
Which one? The one for this morning?
I don't know, Miss Peña. You're muted, Ms. Peña.
Yes, we have something I'm working on. This one will be taken care of, and then I just have to get a plea date on the misdemeanor case.
Okay, so do you want to announce right now? I mean, are you going to announce it or?
We can announce it at, I'm not sure how, it looks like you have a long civil docket.
Yes.
So,
Okay, so so on this one, it's going to be dismissed or what's going to happen?
more than likely, yes.
That's the one where she's co-defendant.
Correct, yes. I just got to call court 5 to see when I can get her in.
The Garza and Cody Quiroz, Samantha Garza. Mr. Sorolla?
It was there.
Mr. Sorolla? Okay, is there a Mr. Cody Quiroz on the Zoom right now? No. Is there a Samantha Garza on Zoom right now? Well, Brenda, I guess the defendants aren't on. We'll just have to wait.
Hello? Hello?
That's oh, join audio. Mr. Sorolla? Mr. Luis Sorolla?
Good morning, Cindy. My name is Luis Garcia, and
Yes, sir.
I'm just inquiring, are you calling in regards to Mr. Cater?
No, I'm calling to see if Cody Quiros is on and Samantha Garza is on so that we can verify their plea paperwork.
Oh, I apologize.
It's okay.
Thank you.
Mr. Sorolla, are your clients on? I don't see them on the Zoom. Mr. Sorolla. Mr. Sorolla. Mr. Sorolla. Mr. Sorolla. Mr. Sorolla. Can you hear me, Mr. Sorolla?
Can you hear me now?
Yes. Are your clients with you in your office, or are they supposed to sign on?
They're supposed to sign on. One of them, Cater, hired an attorney in.
Yeah, I'm not worried about. I just wanted the other two so we can verify their plea paperwork, but I don't see them on. Do you know if they're going to sign on?
Supposed to. Cody Quiros is the other one,
Yes, and Samantha Garza.
and Samantha Garza. They're both supposed to sign on.
Yeah, they're not
At
on.
8 o'clock, I told them at 8. Let me get their files and call them.
All right,
Okay.
good morning, everyone. Apologize for being late this morning. The 357 District Court will call its court session for today's docket, Wednesday, March the 30th, 2022 at 8 o'clock in the morning, starting with 2020 DCL 1362, Aguirre, McDonald's, Mr. Armstrong, and Donato, and others.
Good morning, Your Honor. Ron Armstrong II on behalf of plaintiff, Mr. Aguirre.
Okay, do we have anybody for the defendants here?
I've seen him.
Huh?
Yes, Your Honor, Aurelia Guzman for defendant Mid-South.
Okay, anybody else? Is that the only defendant?
Mike Frieda Bowling for defendant Lopez Foods.
Okay,
And Your Honor, I'm Ed Davis for defendant Martin Brower, and I'm the movement in the motion.
okay. What is the motion about? Sorry.
Judge, it's a straightforward motion, agreed motion for continuance, or unopposed, I should say, motion for continuance. The case was filed last year. Go ahead.
I'm sorry, I don't mean to interrupt you. I apologize for that, but listen, this file's got whiskers. We better be a very good reason why you want another continuance. So,
Well, yes, sir, Your Honor. The primary reason is that 3 parties were recently added, mine being the last, and scheduling order and trial date were all established before my client was served and answered in the lawsuit. So
I get a lot of these, yeah. I get a lot of this last minute joining our parties by the plaintiff, and I want to order that be cut off. If you have not know your case by now, you don't know who the target defendants are, it's too late. So along with this continuance, you will not be allowed to add any more parties.
That's fine, Your Honor.
Otherwise, we'll never get to trial. So do your due diligence, get everybody in that you have to, but no more. What are you looking at, all of you?
Well, Judge, we've actually had some back channel discussions about quickly trying to depose the plaintiff and mediate the case. I think all the parties are on board with doing that here in the next month or two to sort of prevent what would be, I think, a very involved corporate discovery from the remaining defendants that are now in the suit. So we're going to get that done. And the motion had asked for a trial setting sometime after October 15th of 2022, pursuant to what's available with the court. So that's what we are requesting.
If I capitulate to that request, I will do it with everybody's agreement. You will not get any more continuances.
Plaintiff is in agreement, Your Honor.
Defendants,
Lopez Foods in agreement, Your Honor.
Mid-South is in agreement, Your Honor.
all right?
Yes, we are as well. Martin Brower, Your Honor.
Give me a trial date in November. Do I have anything in November? October 31st for what? Announcement? And what happened November 1st? What's our second week look like? No jury? All right. November 14th with announcements on the 4th. No more continuances, no more adding parties.
You got it, Your Honor.
Thank you.
Thank you, Judge. May we be excused?
Yes, sir.
Thank you.
Thank you, Your Honor. Have a good day.
You
Thank
too.
you, Your Honor.
Thank you. All right, 2021 DCL, Mr. Kowalski, you have 2021 DCL 6869 Castorena, you and Mr. Hernandez.
Yes, Your Honor, we're here.
What's going
Mr.
on?
Hernandez. Mr. Hernandez.
Good morning, Judge Hernandez here.
We can start it.
Okay, so what's going on in this? This is a divorce.
We
North
got the
Silver.
final proof of, Judge. We're
right.
working on a couple issues. If Mr. Kowalski is ready to proceed.
Yes, we're ready to proceed. Let's do the prove up
Right.
with a few questions, Your Honor.
Who is here? Ms. Castorena or Mr. Castorena? Are they both here to testify?
Mr. Castorena is here, Judge.
All right. All right. Well, raise your right hands on the screen so that my co-reporter can give you the oath.
We need an interpreter here. Necesitas interpreter.
I'm here, Your Honor.
Mr. Castorena on the screen.
I need your client, Mr. Castorena. Where is he?
He's there, Judge. He was there.
Where is he?
There.
I don't see him.
I don't know if he got booted off. He was logged in, Judge. He might have got booted off.
El plástico del COVID.
You want to wait or you want me to?
Let's go start with this, Ms. Castorena. If you guys have an agreement, Mr. Hernandez, I trust that you know what it is.
Yes.
Then we can
Yes,
get
Judge,
the
maybe one disagreement.
final.
Two.
Wow. Well, that blows the whole thing off, Mr. Kowalski. You're in a hurry.
Mr. Castorena, can you unmute yourself, Mr. Castorena?
Mande.
All right. Both raise your right hands, please.
Levanten su mano derecha.
Do you solemnly swear from the testimony give will be the truth, the whole truth, and nothing but the truth, so help you God?
¿Ustedes juran que lo que se va a decir ahorita en este momento como testimonio va a ser la verdad y solamente la verdad, lo juran ustedes por Dios?
Sí.
Yes, yes.
Thank you.
Gracias.
All right.
Saquen su-
Somebody proceed.
All right. Mr. Castorena, can you please state your name, your full name for the record?
Señor Castorena, ¿puede decir su nombre completo, por favor, para que quede levantado en actas?
Eder Edgardo Castorena.
Eder Edgardo Castorena.
And you're currently married to Irene Bernice Castorena?
¿Y actualmente está casado usted con Irene Bernice Castorena?
Así es.
Yes.
And have you been domiciled in the state of Texas for the preceding 6 months and the county for the preceding 90-day period?
¿Y ha sido residente usted del estado de Texas y del condado de Cameron por los últimos 6 meses?
Sí.
Yes.
Yes.
You were married on or about August 18th of 2018?
El 18 de agosto del 2018 es cuando se casaron ustedes.
Así es. Sí.
Yes.
And ceased to live with your spouses on September 2021.
En septiembre del 2021 es cuando dejaron de vivir como marido y mujer.
Así es.
Yes.
And has your marriage become insupportable due to discord or conflict of personalities between you and the respondent that destroys the legitimate end of the marriage and prevents any reasonable expectation of reconciliation?
Y el matrimonio ha llegado a tal grado de insoportabilidad por conflicto de caracteres entre las partes que destruye la legitimidad del mismo matrimonio y previene cualquier tipo de reconciliación a futuro, ¿correcto?
Correcto.
Correct.
There were no children born or adopted of the marriage?
¿No hubo producto de este matrimonio? ¿No hubo ninguna adopción?
No.
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 Now, as to the community property, you will be keeping the personal effects in your possession, and Ms. Castaneda will be keeping the personal effects in her possession, correct?
En lo que se refiere al patrimonio conyugal, entre ambos, usted se va a quedar con lo suyo, con sus artículos personales, al igual la señora Castorena se va a quedar con lo suyo, sus artículos personales, ¿correcto?
Correcto.
Correct.
As far as the debts, you'll be keeping the debts that are in your name, except for the debts of the Zales Community Credit Card, which will be divided. You will take the bigger portion, and Ms. Castaneda will owe you $320 within 60 days, correct?
En lo que se refiere a las deudas, cada quien se va a quedar con la deuda que tiene, con la excepción de la tarjeta Sales. Usted se va a quedar con la mayor parte de la deuda y la señora Castorena le va a dar a usted o le va a reembolsar $320, ¿correcto?
Correcto.
Correct.
She will also be keeping her car, correct?
Ella también se va a quedar con su coche, ¿correcto?
Así es.
Yes.
And she will be keeping a debt associated with that, correct?
Y se va a quedar con la deuda asociada con esa misma, ¿correcto?
Correcto.
Correct.
That debt is currently in your name, correct?
Esa deuda actualmente está bajo el nombre de usted, ¿correcto?
Correcto.
Correct.
And you're giving her 6 months to refinance the vehicle?
¿Y le está dando usted a ella 6 meses para refinanciar el vehículo?
Así es.
Yes.
Yes.
Do you believe this is a just and right division of the assets and the debts?
¿Usted cree que esta es una división justa para llevar a cabo en lo que se refiere a los bienes de este matrimonio?
Así es.
Yes.
Yes.
And you're asking this court to approve your divorce and sign off on the decree?
Y está solicitando aquí al señor juez que se lleve a cabo este divorcio y que se firme el decreto, ¿correcto?
Correcto.
Correct.
Pass the witness, Judge.
Paso el testigo, señoría.
Mr. Castorena, Mrs. Castorena is asking for 60 days to pay you the $320. Is that okay
Señora
with you?
Castorena, la señora Castorena está solicitando 60 días para llevar a cabo el pago de los $320 hacia usted.
Aquí no.
Así es, está bien.
Yes, that's fine.
Pregunta.
Just a question.
¿Hay cargos atrasados referentes a cuentas solamente para que lo tomen en consideración?
Well, there are charges, past charges in this account, just so you can take it into consideration.
Yeah, I believe the account is up to date and there are no late payments or any interest on it because she's already paid $180 over it.
Creo que ya está todo en regla y porque incluso creo que ya pagó $180 de más en la cuenta, entonces no hay penalidades ni nada por el estilo. Perfecto.
Okay. Yeah, no more questions. May I have questions on my client, Your Honor?
No tengo ya preguntas, le puedo hacer preguntas a mi cliente, sí.
Ms. Castorena, did you hear what just transpired here?
Señora Castorena, ¿usted escuchó lo que acaba de transpirar?
Sí.
Yes.
And do you agree with what was said?
¿Está de acuerdo usted con lo que se dijo?
Sí.
Yes.
Are you also asking this honorable court to restore you to your maiden name?
También le está solicitando aquí a este honorable juzgado que le restaure su nombre de soltera.
Sí.
Yes.
Which is, ¿cuál es?
¿Qué es?
Es Irene Berenice Aquino.
Irene Berenice Aquino.
And are you asking for the divorce?
Está solicitando este divorcio.
Sí.
Yes.
No more questions for this witness, Your Honor.
No tengo más preguntas para este testigo, su señoría.
Okay, the court will take judicial notice of all documents on file in this case. The court will have, find that it has jurisdiction by virtue of the domiciliary requirements of the family code. The court having heard the testimony of both petitioner and respondent in regards to their agreement for division of any community estate existing between the parties, personal and real. The court hereby approves the agreement. The court hereby grants the divorce if prayed for. The court hereby restores the name of Irene Bernice Casorena to Irene Bernice Aquino as requested, and any other relief not mentioned here or presented in court is denied. Anything else?
Nothing else.
Thank you.
Thank you, Judge. May I be excused?
Yes, have a good day.
Thank you.
2021 DCL 5075 Ally Bank, Marta Martinez Caballero de Caballero.
Morning, Your Honor. Anthony Santini on behalf of Allied Bank.
Marta Martinez de Caballero. Proceed.
Your Honor, we're attempting to get default judgment here and obtain possession of the collateral due to missed payments by the defendant. We request the order that we proposed executed, and we will request a writ of possession to provide to the sheriff shortly after. That's it, Your Honor.
All right. The court having called out the name of Marta Martinez de Caballero hereby grants the judgment as requested. And what did you ask me for, a writ of attachment?
Writ of possession, Your Honor. We're just trying to get possession of the collateral.
That will be granted.
Thank you, Your Honor. May I be excused?
Yes, sir. Have a good day.
You too, Your Honor.
Mr. Castorena, your case is over. You can log off.
Okay, thank you.
Mhm.
All right. Let me call out, is she still on the line? Well, how are we gonna do this? What's her name?
Santiana, are you there?
Miss
Who?
Miss what?
Santiana.
This is 2016 DCL 4265, State of Texas versus David Andrew Vasquez. Who do we have here in that case?
Good morning, Your Honor.
Just,
Oh, sorry.
no, go ahead, Juliana.
Thank you. Good morning, Your Honor. Juliana Sosa here on behalf of Mr. Vasquez. We just got retained yesterday, and we filed a notice of appearance yesterday. Mr. Vasquez had previously had Miss Alegria as counsel.
Right.
And Your Honor,
Where are we
Joshua
at?
Schamberger for the Office of the Attorney General.
Okay, and who filed this?
Mr. Vasquez did, Your Honor. It's my understanding from looking at the history of the case and all the pleadings that were filed by Miss Alegria, she had also filed an objection to the Attorney General's administrative order. I guess they were trying to fix child support, but the circumstances have changed since that was filed last year.
Who is Miss Santiana in this whole affair?
Miss Santiana is there's three parties. There's mom, who I believe is Miss Santiana, I mean the grandmother, and then there's the mother, right? What's her?
Jessica Hernandez, Your Honor, is the mother, then the grandmother. So originally, Your Honor, the grandmother had custody. Both mom and dad were ordered to pay support to the grandmother. The grandmother is unfortunately very sick in the hospital or hospice or something like that. So the child, I believe, went to Mr. Vasquez. They did a temporary order about a year ago, giving Mr. Vasquez custody, saying the child support obligations for the dad, Mr. Vasquez, and the mother, Ms. Hernandez, stopped. So, and mom's never appeared. So we're not opposed to obviously dad having custody. I mean, the child's with him. That's what the testimony elicited last time. We filed the motions to confirm what each parent owes to the grandmother. So from our perspective, that's what we need addressed. And then we also, the temporary orders that were done didn't really address medical support. So who has coverage for the child? If neither has private coverage, then dad would need to apply for the government program. Mom would need to reimburse something. So that's our perspective.
So update on that, Your Honor. my client was granted custody last summer, and this child was with my client all summer until he started going to school. Then mom took him and then told the child, like, I'm going to kill myself. You go back with dad. Dad didn't want to stress out his son anymore. So he kind of have just been playing nice with mom. Mom has had the child physically. She has not let dad see the child, even though he legally has custody.
Wow.
So we're asking for an amicus attorney at this time to address the issues.
But there must have been a good reason why neither one of these parents were granted custody of this child to begin with.
Yes, my client was 18 years old. They were super young when they had this child. And I know my client had gotten into trouble. And so he was getting all his life together.
Here's what I want you to do, counsel.
Yes.
I want you to prepare a writ of attachment for my signature to attach that child and bring him back to the custody of your client.
Yes, Your Honor. We'll do that. We'll do
She's
that.
in direct violation of her order.
Yes, Your Honor. It's a signed order, so she can attach the order. It is signed by the court. It was signed a year ago.
Signed and all that, so you just need to do a writ of attachment to any deputy sheriff in this county to go get the child wherever he may be and restore him to the custody of your client.
Yes, Your Honor.
And if she has any beef with that, she can come and complain in court. Now, as far as the matter of the arrearages to the grandmother, this is actually the arrearages to
final.
This would be the arrearages to the state, right?
Well, no, it's to the grandmother. I mean, there may be some state owed as far as like medical support or things of that nature. But I mean, normally the child support arrears would be owed to the grandmother, and the medical is typically owed to the state in our cases.
Well, I want to call that a wash because grandmother's on the phone right now in Santa Ana. She is in a, what is it? Nursing home? No, what is it?
Miss Tatiana, are you in a nursing home? Yes.
What?
I'm in a rehab.
For what, Miss Tatiana?
I had the COVID, so I'm in a rehab for a walk.
Okay. She's in a rehab hospital attempting to regain her physical condition after a bout with COVID. So I think we'll leave the arrearages pending until she gets better.
Yes, Your Honor, that's perfect. That's going to be my suggestion, Your Honor. We can hold off on that until we're ready to finalize.
But as far as the other thing, Ms. Sosa, I think we pretty much that will resolve it.
Yes, Your Honor.
The mother has absolutely no right doing this, and whatever. So we need to take action on that and restore the child to your client.
Yes, we'll get that done today.
That is pursuant to a lawful order. If she's got an issue with that, she needs to come and change the order here.
Yes, Your Honor.
Okay, thank you.
Thank you.
And then, Your Honor, the date for final hearing to finalize?
How much, what do you think about, what, 60 days, 30 days, what?
It's when this case has been pending for a while, so
I know it's got more than whiskers.
yeah. So the only thing would be for Ms. Sosa to do the writ of attachment, because mother has never appeared for any of the settings that we've had.
I seem to remember this file. It's got a history, I think.
Yes, Your Honor. So it's really at the court's discretion or Ms. Sosa's discretion since he's just joining it, but it's been pending for a long time.
How long will it take?
For
How long
30
will it take you,
days.
Ms. Sosa?
I will get it done this week, Your Honor. It's Wednesday, so we can get it done before Friday. And then,
We set it for 30 days.
yes,
30 days.
Okay, let's set it for April 29th.
April 29th.
yes, Your Honor.
Yes, Your Honor. And is it going to be at 8 via Zoom or in person, Your Honor?
I can do it in person if you all want to. I don't see.
Well, I didn't know. I know some courts are going back in person. That's why I asked, because we're bouncing around.
Yeah, it's all discretionary. If I can handle it Zoom, I'll do it Zoom for right now. But if I need to bring them live, I will bring them live. Those are options that are available still, So it's my call, and and I'll go along with whatever the parties want. If you want to do Zoom, we'll do Zoom.
We're good via Zoom, Your Honor.
The problem we have is in Santa Ana does not have any internet, doesn't have anything like that. So she's gonna have to be here in person. So if she's coming in person, I would ask, I guess, that all of us be in person, no?
Okay, that's fine for the state, Your Honor.
All right. Okay, in person, Miss Indiana, when you get out, I'm gonna give 30 days. Hopefully you'll be out by then.
Okay,
And if you're not, you call before, when you find out if you're gonna be released in 30 days, if you say, no, you'll be there longer than that, you call Ms. Salas to let me know that you're going to be in the hospital longer than 30 days, okay?
okay, sir.
That way I'll notify all the other parties that we're gonna need to move it for a little bit longer until you get up and about, all right?
Okay, thank you, sir.
You're welcome, ma'am. All right, so Ms. Sosa and Mr. Schomburg, it's gonna be somewhat of a moving target. It's gonna depend on her getting out of that hospital and regaining her full use of physical attributes. So she's gonna call us, and those might be subject to change, and we'll advise you when we'll change it and prolong it a little bit longer, depending on what she tells us, okay?
Yes, Your Honor, sounds good.
All right, thank you. So for right now, it's April 29th.
Yes, Your Honor.
Thank
That's
you.
all
Have
we
you
have.
excused?
Yes, sir. Have a good day.
Thank you.
All right. (2021) DCL 5034 Marta case versus Eleazar Castillo. This is a nightmare reading for me on this discovery dispute.
Good morning, Your Honor.
All right, let's have announcements. So who's here for that case?
Your Honor, my name is Nagin Roberts. I represent the plaintiff, Martha Cost. I believe we have collectively, the parties have 6 motions before the court today.
I know exactly what you have, Ms. Roberts. I like to read my files, especially these files before I have a hearing. The fact of the matter is that I didn't have time to finish them, so that I could summarily tell you what my ruling was going to be on all this discovery stuff. Because it seems to me that if you guys, within your own collective judgments and wisdom and experience, cannot get together and resolve this issue on your own, then the court is forced to do that. And the court, before it does that, likes to read the objecting interrogatory, the objecting request for production, the request for admission, and whatever on the grounds that is too broad. And I'm not going to rule on relevancy because that's going to be overruled automatically. I determine, and I alone determine what's relevant in this lawsuit or not. So I would like to ask every one of you to prevail on you to try to go in there and work some of this stuff out. This morning, I am going to send you to a breakout room, all of you. And I want to give you some time to try to resolve some of these issues and come back to me to the ones that you really are stuck on.
Judge, may I address the court?
Yes.
I'm Pat Walter. I represent Eli Castillo and Alamo Concrete. I've been doing this about 40 years and I've handled hundreds of vehicle accidents, and I know you have too. I filed a motion for protective order when I got 228 discovery requests on a simple vehicular collision, and they're all geared to commercial motor vehicles. This is not an 18-wheeler. The guy was a salesman with a Class C driving a pickup truck. So I did it out of irritation, a motion for protective order to not have to answer every commercial motor vehicle question in there. So that's just a predicate to where we've been and where we're going.
All right. Anybody else? All right, Miss.
Who am I sending in there?
Ms. Roberts? But she just disappeared.
I don't know.
Ms. Roberts? Oh, there you are. Ms. Roberts? Well, she's frozen.
Okay.
Your Honor, I'm Brad Bartlett. I represent one of the defendants in the case. I've worked out my issues with the plaintiffs. I can go to the breakout room just for a moment, but other than that, may I be excused?
All right, as long as we go in and figure out that your issues are done. Hold on a second.
Thank you, Judge.
Ms. Roberts on. Who,
Is it just going to be Mr. Bartlett, Mr. Walter, and Ms. Roberts?
Yes.
yes.
Well, I'll open the room and it'll prompt her when she's unfrozen her. The room is open.
The room is open, Ms. Roberts.
I'm sorry, my internet cut off.
It's having a little trouble. The room is open, the breakout room. Join out the breakout room and get into an earnest discussion about this discovery disputes, please.
Yes, Your Honor, thank you.
All right, what else do I have here?
Hold on, Judge. It didn't assign her.
Thank you.
You're welcome. Okay.
All right. Do we have a criminal docket?
Yes.
2021 BCR 2464, Septex versus Brittany, Roxanne Williams, Ms. Peña.
Good morning, Your Honor. We have an agreement right now. They're going to be dismissing our felony case if we plead to the pending misdemeanor case. I just need to get with County Court 5 to set a plea date on this matter.
Okay.
So that we could have maybe a week or 2 weeks
Okay.
to reset this matter.
Ms. Salas, 2 weeks. Of what? 13th of April, Ms. Peña.
Very well. Thank you, Your Honor. May we be excused?
Yes, have a good day.
And she is on log. Thank you.
Okay, have a good day.
Thank you.
All right. 2021 DCR 2464, Christopher Charles Cater. Mr. Sorolla.
Morning, your judge. Go ahead.
Good morning, Judge. My name is Luis Garcia. I'm an attorney here in Corpus Christi, Texas. I have filed a motion to substitute, Your Honor. And I have been in contact. I have been in contact with Mr. Sorolla, sir.
Okay.
No objections, Your Honor.
All right, that'll be granted. What are you looking at for here? We're set for trial. Are you ready?
I am not ready, Judge. I do not leave very much time. If the court can give me maybe 30, 45 days at the most.
That's a lot of time, Mr. Garcia. I thought that not much time. I thought it was 2 weeks. But 30, 40 days, let's call a spade a spade. So why do you need so long?
I don't know if there are any preliminary motions that need to be filed, Judge. I have spoken to Mr. Sorolla, but I can, like I said, I can continue to speak to him to see if he can send me some of the file notes.
I'll give you 30 days.
But just
30
out
days.
of caution, I will just, sorry, I apologize.
I'm gonna give you 30 days.
Yes, sir.
We set this for a trial. Yeah. But, and also, did you file a notice of appearance, Mr. Garcia? And a written.
I did, Your Honor.
And a written motion to substitute counsel that we can make sure that we take Mr. Sorolla off here, off this thing.
Your Honor, we e-filed a notice of appearance, or actually a substitution of counsel, and we asked Mr. Sorolla to sign it, and I believe he signed it this morning. So we can also e-file the signed signature motion if you want me to.
You'll get noticing directly of anything that goes into this file. I mean, I don't want to, have a problem with the chain of command here. All right.
Yes, sir. Yes, sir.
Can you look in the e-file and make sure that we have a motion to substitute counsel or a notice of substitution of counsel, whatever.
There's nothing in the Odyssey yet. I'm thinking maybe because it was lacking Mr. Sorolla's signature. So I'll keep an eye out this morning for it.
All right, that sounds good.
And Judge, I do have an envelope ID number, but but we'll contact the court as well.
Yeah, Ms. Solis will take care of it. She's a hound dog on that one. She'll track it down to the person responsible for this.
Yes, sir.
Thank you. All right, 2020 DCR 2607, Cody Reynolds Quiroz, Mr. Sorola.
Mr. Quiroz is on, Your Honor. It's a plea.
All right, and 2021 DCR 2876, Samantha Garza.
Judge, on Miss Garza, I didn't have time to pick up her plea paperwork. Can I have next week with her? I'll pick it up. We have an agreement with the state.
So you have only one plea this morning?
Mr. Quiroz, yes, Judge.
All right, give him 1 other week for Garza.
Judge, may I be excused?
Yes, sir. I'm sorry.
Thank you,
Yes,
Judge.
sir. Take care.
Thank
Have a good day.
You too.
You can give him a date.
I need the date for next week.
April 8th, Mr. Sorola, for the,
Okay.
for Ms. Garza.
Yeah, the other guy, give him the date.
Mr. Sorola, we have the plea paperwork. Can you not find her? Is that the problem?
No, she's signing on. If I turned it in, then.
I have it.
Okay, then she's signing on. She called this morning. I think I gave her a wrong Zoom code, an old one, but we just got off the phone with her. She's getting on right now.
Okay.
Let me.
Mr. Sorola, does any of your clients need an interpreter?
No.
Alejandro, we're done with you.
Mr. Quiroz, you speak English, right?
Yes, sir.
All right. Hang tight.
Bye-bye.
Bye, Alejandro.
Thank you. Bye.
Okay, Mr. Cody Quiroz,
Yes, ma'am.
did your attorney explain this paperwork to you?
No.
He didn't explain them to you?
No, I had just barely hopped on the Zoom because I didn't know what time it was supposed to start because I didn't get no message or anything. So,
Mr. Sorola,
Mr. Quiroz, do you understand the plea paperwork that you signed?
oh, my plea paperwork, yes, sir.
Okay, thank you.
these are the plea papers, sir.
Oh, yeah, I understand.
I just need to confirm that your attorney explained them to you.
Oh, yes, ma'am. The paperwork, yes, ma'am.
Okay. And is this your signature?
Yeah,
Okay, thank you, sir.
thank you. Was that it?
Now, hold on for the judge to call.
Wait for the judge. The judge is gonna ask
Okay.
you questions. You go through it and then you'll be done, okay? Hang tight.
I'm sorry. I don't really know about the Zoom thing.
You can go ahead and mute it until your case is called back.
All right.
Okay, what happened with?
Brenda, Miss Garza finally logged on.
Samantha Garza?
Yes.
Okay. Did your attorney explain this paperwork to you?
Yes.
Do you have any questions for your attorney?
No.
And is this your signature?
Yes.
Okay, thank you, ma'am.
Sit down. Here. Sit down.
Ms. Garza, can you mute yourself, please?
Yes.
Thank you.
Can y'all hear me?
Yes, sir.
Okay, sit tight.
Judge, Mr. Walter is asking for help in the breakout room. Let me join him real quick and see what they need. Okay, Judge, Mr. Walter and Ms. Roberts are back from the breakout room.
All right. What do we have to report on Castillo?
Your Honor, Pat Walter for the defense. Ms. Roberts and I have been communicating over many months. We communicated again. We've narrowed the issues, but we're going to still have to have some rulings. And some of it is maybe just because I'm crotchety in my older age, getting hit with a bunch of commercial motor vehicle type questions when this is a Class C driver. And so we're going to need some rulings on some of that. I think the DWQs, where I'm trying to get the medical records and billing and radiology on our client to evaluate, we've come to an agreement on the time span, but counsel for the opposition wants to make a relevance argument on some of the records that I'm pursuing.
That is not foreclosed at all. Look, I will listen to prior to this going to trial, if it does go to trial, the pretrial date that I will have set for you will be for the sole purpose of cleaning up any and all objections to evidence that you propose to use in the trial of this case. At that time, we will go over not only relevancy objections, substantive objections, whatever the problems you have. The mere fact that you're agreeing to provide the records does not make them admissible per se. I still have to rule on their admissibility. I am the gatekeeper of that stuff, and I certainly welcome the opportunity to rule on objections if councils have made them as per the rules. That's the way I handle these things, okay? That's the way I handle these things. So yes, maybe a lot of the information that you're about to give them is irrelevant, and that irrelevancy highway travels both ways. So I will rule on that, on those pre-trials. So so having said that.
Your Honor, I'm okay with that, Your Honor. I understand your position and your thought process on that. All I ask Mr. Walter is that if we can get, because he is asking for all of my clients' records for we've narrowed the time, but all I ask is if we can maybe review the records, if we can get them first for even 5 days to just see if there's anything privileged or objectionable, and then we'll provide a log if so, and then the records retrieval company can then provide it to Mr. Walter.
May I respond to that, Judge?
Yes.
But the problem is this: we're set for trial in December. I know this court didn't like delays. I don't like delays. I like to push my cases. I like to try cases. It just delays the process. What I've offered is this. I said, as soon as I get the records, I'll drop box them to you free of charge so that counsel will have them, can review them. If there are any objections, Judge, you're going to rule on it. And I even offered confidentiality. I said, all I want is to defend my clients on this case. So to delay the process so they get to look at them, and then we have to come back to you and hassle you for more rulings, I object to having to do that. Let's just get the records. I'll produce them in Dropbox. I asked for 10 years, which I thought was reasonable. We agreed to 7. And I said, if I find a bunch of stuff that looks like it's important, we may come back for another 7. But I think it's reasonable to do as I've suggested.
Your Honor, if I may also respond real quick, I think my request is reasonable under the circumstances. He has requested an unlimited scope of records to places including hospital, urgent care. I asked Mr. Walter if we can limit that to just the issues in this case, which is back and neck, even mental health, because she is claiming mental anguish. He did not agree to that, and Your Honor is saying that you will want just keep everything relevant until trial, which I understand. All I ask then is that we have 5 days. I don't think that is going to interfere with or delay the case in any way. You know, it's a reasonable.
You want 5 days for what, counsel? I'm sorry, I missed that.
Sure. The records retrieval company. I'm sorry.
You're having internet problems still. Go ahead.
I'm so sorry. Yeah, my connection is not the best today. I don't know why, but the defendant's all I ask is that defendant's record retrieval company just send the records directly to us first for a review.
That'll be denied, counsel.
Okay.
That will be denied.
And then the next thing I stipulated too, Judge, I stipulated that.
All right, hold on, Mr. Walter, before you moved on, I want to make sure that we've left this and we're not coming back to this. So that will be denied. You will preserve your relevancy objections or other privileged matters you have in a timely fashion so that they will be the subject of a pretrial order hearing. Because I intend to, if there are a lot of issues percolating regarding relevancy or privileged matters, I will make sure that I have a pretrial that give you enough time so we can go over all these documents to make sure that, you know, I make the rulings accordingly, okay?
Okay, then that takes care of all the motions to quash. There's 3 of them that were filed by opposing counsel.
Yeah, they will, based on that, they're overruled and you can reissue the notices and then we'll work it from there.
Well, Your Honor, in the
Now,
same
hold on a
token,
second, but hold on. Let me just give Mr. Walter what's sauce for the goose is sauce for the gander, Mr. Walter. If you brought in and you think in your mind that 7 years is a reasonable time, then I will apply that same rule to you on her discovery. 7 years back is reasonable time according to you. There are I saw some discovery items where you objected to it being overbroad for the time because they went back 10 years. So they're going to apply to you 7 years.
Understood.
You feel that that's reasonable, so you need to delineate your discovery, Ms. Roberts, to 7 years before.
yes, Your Honor.
All right, what else?
The only other 2 big ones, Your Honor, are we have requested in this case defendant's cell phone records as well as his GPS records from Geotap. The defendant vehicle in this case, it's a company vehicle, had in it installed a software called Geotap, which defendants themselves admit are used to not only track their location and speed, but it also tracks driving infractions. It has trigger points. It can detect if there's hard brakes. In this case, the evidence is clear the defendant causes collision.
Let me interrupt you. I read your pleadings and everything that's filed, and it's abundantly clear to me that it appears that from your position that this is a clear liability, that there's been no violations per se that you have alleged because he didn't do things. So what?
Judge froze.
What's the objection, Mr. Walter, to that information?
Sure. My only objection is I'm fine with it myself. My guy, of course, denies being on the cell phone, but obtain the cell phone records, but they want them for 3 months, his cell phone. No, that's just a fishing expedition. How about the day of the accident? That's fine, the day of the accident.
Your Honor.
Yes. Why do you want them 3 months before?
Your Honor, this is precisely why we need it 3 months before, or we need cell phone records and GPS records for a meaningful duration of time. Aside from the claims that we have against the driver themselves, the records that we need for a time period are more tailored for the claims against the company. We have pled in this case that the defendant engaged in a pattern and practice of ignoring safe driving practices, and that it engaged in a pattern and practice of not auditing its driver's cell phone records and GPS records. This driver in this case got a citation for disregarding a traffic sign. If I don't have his GPS records or cell phone records for a meaningful duration of time, I cannot prove that claim. The company in this case had a duty. It had
You cannot prove what claim?
specifically, Your Honor, that the company engaged in this of failing to enforce its cell phone policy and its policies and procedures as it relates to safety, so as to allow its drivers to continuously drive recklessly. If the company had reviewed this driver's records, GPS records, and it saw—
Well, but isn't that relevant only to the times that he's had an incident?
Well,
I mean,
precisely.
so what is the GPS tracking to say? Well, you know, he's acting recklessly. He's speeding. He's been speeding habitually. He's a speeder, and they ignore that. Did speed have anything to do with this?
Well, Your Honor, it goes back to unsafe driving. If in fact his GPS records, because whenever a driver is speeding, or if he's doing a hard brake, or if he's doing some kind of thing that triggers—
All right, here's what I'm gonna do. Here's what I'm gonna do. I'm gonna give you the records, the GPS and the tracking records for 2 weeks before that. If in that discovery, you find that it leads a thread that you're going to unravel, that it may lead to further whatever, you need to be more specific as to evidence that you find that will lead you to that conclusion that they have been mindless and reckless and ignoring all this negligent conduct on behalf of this driver. You can come back to me if you find something there. So I'll give it for that day of the accident and 2 weeks before.
I understand the ruling, Judge. On the cell phone, I would ask that it be the day of the incident. It's his personal cell. If it looks like he was on the cell at the time of the accident, then they can go further back.
Yeah.
They should just fix.
Let's do that for the day. Right now, to unstick this discovery, do it for the day of.
Thank you.
And if he's not using it, he's not using it.
Your Honor, that's fine. That's fine. I was gonna just say though, in part of me doing my due diligence, we always request cell phone. I need the cell phone records in the same time as the GPS records, because once I can—
You have them for okay, well, you have them for 2 weeks. Give them for 2 weeks, but they're his personal cell phone. You are to maintain confidentiality of those personal records.
Yes, Your Honor.
They're not company records. They're his personal cell phone.
Yes, Your Honor. There's no like substance. It's just telling me if he's texting while driving, if he's on the phone while driving.
That's fine. So it'll be for 2 weeks, and you maintain the confidentiality of those records.
Yes, Your Honor.
All right. What else?
There was a motion to quash, Judge, and you may have taken care of it. The council moved to quash some records from Benchmark Wellness Center, from HEB Pharmacy, and from Cardiology Associates. And my nurse paralegal, in doing a detailed analysis of what few records were produced in disclosures, found these medical providers. So we issued DWQs to them to get the records. They moved to quash and to object. And the reason I wanted them in part is I found out she had a lumbar MRI just a month before our accident. And that was never revealed in response to our discovery. We only got objections. So I want that overruled too, Judge.
Your Honor, he has requested records from Coastal Cardiology Association, Benchmark Wellness Center, which is a cardiovascular and internal medicine place. For Benchmark, she went there for COVID tests. That has nothing to do with this case. Cardiology, she hasn't gone there as a result of this collision. She has a heart condition called something valve, mitral valve prolapse. It has nothing to do with this case. She's had it for over a decade, and she just goes there to get an EKG or maintenance. These are not providers that she has seen as a result of this collision. Maybe it was mentioned in one of her records that these were her, primary care or something, but she's not claiming in this case that she has her heart issue got exacerbated or worse.
Well, the ruling that I made before, you lift your objections, let him get those records, and then you come and can load it for bear on pretrial day as to why those records should not come in or that testimony should not come in. Okay?
Okay.
Thank
All
you.
right. All right. Anything else?
Thank you.
Anything else?
I don't believe so.
Mr. Walters?
Your Honor, thank you for your time. Again, I have to do this, but not very often, but I appreciate it.
All right. Now, listen, Miss Roberts, you get back to me after you get some of that discovery. And if in fact you find something that you think needs to be explored to sustain or to as part of your burden on whatever you're going to allege, you let me know. Okay?
Yes, Your Honor. Thank you very much.
Well, you're welcome. Have a good day.
Thanks, Judge.
Thank
Bye-bye.
you.
All right, Mr. Quiros and Ms. Garza, please raise your right hand and unmute yourselves. Do you solemnly swear from the testimony you will be the truth, the whole truth, and nothing but the truth? So help you God. Mrs. Garza.
Yes.
Mr. Quiros, unmute yourself and give me an answer, please.
Yes.
Mr. Sorolla, are you on?
I am ready to go.
All right.
This is 2021 DCR 2607 Senator versus Cody Reynaldo Quiros. Is that the true and correct name?
Yes, sir.
All right. And this is also 2021 DCR 2876 Senator Samantha Garza. Is that the true and correct name?
Yes, sir.
All right. You all stay unmuted because I want to be talking to both of you.
Okay.
All right. Starting with you, Miss Garza. Your attorney tells me you wish to enter a plea of guilty to certain charges in the indictment. Please tell me what is it that you're telling me you're pleading guilty to?
To both charges.
To what?
Both charges.
I didn't hear you.
To both charges.
What are they?
The invading in a motor vehicle and endangerment of a child.
What's reduced to a state jail felony? The evading or the Mr. Sorolla?
The evading is a state.
Can you help me out? What did you all agree to here?
Judge, they're both state jail felonies and they're going to be reduced under 1244A to Class A misdemeanors, to the lesser included.
But what are the charges? I say I have count one. What is in count one of the indictment?
Count one is abandon, endangering a child, criminal negligence. And count two is evading arrest or detention with a vehicle.
Well, do you understand that, Miss Garza? What?
Yes, sir.
Then do you understand that the range of punishment for both of those charges are actually for the charge of abandoning the child and endangering the child, count one of the indictment, reduced to a state jail felony, but this punishment was a Class A misdemeanor. The punishment is confinement in a county jail for a term of up to 1 year. In addition, I can impose a fine not to exceed $4,000. Are you aware of that?
Yes, sir.
And also on count two, which is the evading arrest or evading law enforcement, that's also a Class A misdemeanor, which is county jail up to 1 year. In addition, I can impose a fine not to exceed $4,000 on that charge. Are you aware of that?
Yes, sir.
Are you doing this freely and voluntarily?
Yes, sir.
All right. Mr. Quiros, what is it that you're pleading guilty to?
I don't really know. I would like to know my charges though, because I didn't really read the papers.
There you go, Mr. Sorolla.
Okay, if we can reset Mr. Quiros,
I'm not gonna reset it. I'm gonna send you to a breakout room with him so that you can go over and get it done this morning. Mr. Quiros.
Yes, sir.
I'm gonna send you to a breakout room, so you need to prop your computer to go to the breakout room with your attorney where nobody else can listen to you except just you and your attorney. And he wants to go over the stuff with you to make sure you understand what you're doing here this morning.
All right.
You're not, okay,
Yes, sir.
hold on a second.
It's open.
Okay, prompt. All right. Miss Garza, hold on a second. Let me see what. Is it necessary? Oh, please.
Oh, Judge, you're muted, Judge.
Mr. Quiroz, I was asking you, what were you pleading guilty to?
You're a third-degree felon, evading arrest in a motor vehicle.
All right. You understand that violation of a third-degree felony in the state of Texas calls for confinement in prison for a term of not more than 10 years or less than 2. In addition, I can impose a fine not to exceed $10,000. Are you aware of that?
Yes, sir.
All right. And are you doing this freely and voluntarily?
Yes, sir.
All right. Under Mr. Sorolla, is it necessary to rearrange either one, Mr. Quiroz or Mr. Garza?
Either one of my clients requires rearrangement, Judge.
Requires?
Neither one requires.
Okay. All right. All right. Understanding what you're pleading guilty to, understanding what the charges are, understanding what the range of punishment. And now ask you, Samantha Garza, on cause number 2021 DCR 2876. What is your plea to the charges of abandonment of a child, state jail felony punishable as a class A misdemeanor? Now it's alleged on count 1. Guilty or not guilty?
Guilty.
And what is your plea to the misdemeanor charge of class A misdemeanor charge of evading law enforcement authorities as alleged in count 2? Guilty or not guilty?
Guilty.
All right. Mr. Quiroz, understanding what you're pleading guilty to, understanding what the range of punishment, and I ask you in cause number 2021 DCR 2607, what did you plead to the charges of evading arrest, third-degree felony? Guilty or not guilty?
Guilty.
Are you both citizens of the United States, Mr. Garza?
Yes, sir.
Mr. Quiroz?
Yes, sir.
Are you both pleading guilty to your respective charges in your respective indictments, as you have just pled, because you're in fact guilty and for no other reason? Ms. Garza?
Yes, sir.
Mr. Quiroz?
Yes, sir.
Are either one of you pleading guilty out of any persuasion of fear, hope of pardon, force, threats, or promises of any kind? Ms. Garza?
No, sir.
Mr. Quiroz?
No, sir.
Has either one of you ever been in a mental hospital or treated by a doctor for any mental disorders? Ms. Garza?
No, sir.
Mr.
No,
Quiroz?
sir.
All right. Mr. Sorolla, you find Ms. Garza as well as Mr. Quiroz competent and able to assist you in the defense they may have in this case?
Both clients are competent and both clients have assisted me in their defenses, Your Honor.
All right. Your plea of guilty comes to me with a recommended sentence, I believe. In your case, Ms. Garza, it's 12 for 12 under each one of these counts, count 1 and count 2. And Mr. Quiroz, you also have a recommended sentence. In your case, it's 3 years deferred adjudication. What you need to know about that is that the decision of whether to follow the recommendation or not is totally only up to me. Do you understand that, Ms. Garza?
Yes, sir.
Mr. Quiroz?
Yes, sir.
If I, after further evaluation, determine that this is not an appropriate sentence, I will reject it. If I reject it, I will allow you an opportunity to proceed to a jury trial as it's your right to do so in the first place. Do you understand that, Ms. Garza?
Yes, sir.
Mr. Quiroz?
Yes, sir.
The flip side of that coin is if I accept it, if I sentence you to what they have recommended, you may not appeal your case without the court's permission, except as to the pretrial motions that Mr. Sorolla may have filed in your respective cases prior to today. Do you understand that, Ms. Garza?
Yes, sir.
Mr. Quiroz?
Yes, sir.
In that case, I'm going to find that your pleas of guilty are freely and voluntarily made, and you're both competent to stand trial as the state to produce evidence to substantiate the plea in state offense versus Samantha Garza.
It offers exhibits 1, 2, and 3 into evidence.
No objections, Your Honor.
To be admitted. Also, as the state to produce evidence to substantiate the plea in state offense versus Cody Reynaldo Quiroz.
State offers exhibits 1, 2, and 3 into evidence.
No objections, Your Honor.
To be admitted. Mr. Quiroz and Ms. Garza, I have in my hand two sets of documents, one for Mr. Quiroz and one for Ms. Garza. They contain all the documents that are relevant to your case. They consist of 3 exhibits. I want to go over exhibit number 1 with each one of you. Exhibit number 1 in your plea packet is Ms. Garza, is a 9-page document. On page 7, there's a signature line. There appears a signature. Is this in fact your signature, Ms. Garza?
Yes, sir.
Likewise, with you, Mr. Quiroz, your plea packet consists of 3 exhibits. Exhibit number 1 consists of 9 pages, and on page 7, there is a signature line. There's a signature already on there. Is this in fact your signature, Mr. Quiroz?
Yes, sir.
All right. Both of you, were you aware of these circumstances? When you signed this document, were you aware of you were waiving, you were giving up all your constitutional rights to a jury trial, your right to remain silent and not to incriminate yourself, and your right to confront your accusers? Is that what you intended to do, and is that what you want to do, Ms. Garza?
Yes, sir.
Mr. Quiroz?
Yes, sir.
All right. Further, both of you have represented to me that with respect to exhibits 2 and 3, not 1, but 2 and 3 attached to your respective plea packets, you both are asserting to me that you have an agreement with the prosecution, you have agreed with the prosecution, that those 2 exhibits which are true and correct copies of the original arrest reports, incident reports, lab reports, or whatever other reports were generated as a result of respective arrests, the reason you're pleading guilty to me this morning. Is that in fact your agreement, that they are original and true copies? Ms. Garza? Ms.
Yes,
Garza?
sir.
Mr. Quiroz?
Yes, sir.
All right. Well, in that case, I'm going to find as to each one of you that you have voluntarily and intelligently waived your constitutional and statutory rights, and the evidence offered by the state does substantiate your plea of guilt. The court accordingly will find you, Ms. Garza, guilty of as alleged in count 1 and count 2 of the respective indictments. What is Ms. Garza's background?
She has no criminal history, Judge.
All right. Because consistent with the plea agreement, the court here places Ms. Garza on probation of 1 year, order 1 year confinement in county jail on count 1, 1 year confinement in county jail on count 2. The cases are to run concurrent, and the court is going to suspend the imposition of said sentence and place her on probation for 1 year. Under the following conditions, Ms. Garza, what do you do?
What do you mean, sir?
What do you work at, or do you work?
Right now I'm working at a warehouse where we hang parts.
You hang what?
Car parts.
Okay. How long have you been working there?
It's already going on 3 months.
All right. And is that an 8 to 5 job or what?
It's 3 to 11.
Okay. Mr. Cortez.
Yes, Your Honor. Good morning. The defendant will remain arrest-free.
Ms. Garza, you need to pay attention to Mr. Cortez. He is the probation department, and he's telling you what conditions of your probation are. Do you understand that?
Yes, sir.
Did you understand the first one?
Yes, sir.
No more handcuffs hitting your hands, Ms. Garza. If they do, you have violated my conditions of probation, and I'll sentence you to the 1 year in county jail. Do you understand that?
Yes, sir.
All right.
Alcohol and drug assessment,
Yes.
random UAs,
No.
breathalyzer,
No.
restitution if any,
If any.
obtain or maintain gainful employment,
Yes.
GED, high school diploma,
Do you have it, Ms. Garza?
No, sir.
How far did you go in school?
Only up to 8th grade.
Well, I'm gonna order you to attempt to get a GED, if you can, on the computer.
Yes, sir.
that'll be on our part right now, Your Honor. May I have her phone number?
Yes, Ms. Garza, I want you to give me a phone number that probation officers can get in touch with you 24/7. What is your phone number?
956-281-8780.
Thank you.
Court will give her 180 days to pay the court costs. Thank you, ma'am. What is Mr. Quiroz's background?
He has no criminal history, Judge.
Right. Court hereby will follow the recommendation assessment in this court and not find Mr. Quiroz guilty, but instead will defer his finding of guilt for 3 years. He will be placed in deferred adjudication probation under the following conditions. Mr. Quiroz, listen up, Mr. Quiroz.
Defendant will remain arrest-free.
No more arrest, Mr. Quiroz. No more trouble. All right.
Alcohol and drug evaluation,
Yes,
random UAs,
yes,
breathalyzer,
no,
restitution of any,
yes.
obtain or maintain gainful employment.
Are you working, Mr. Quiroz?
Yes, I'm working in demolition, but I just came down like 2 days ago because my girlfriend is due in 2 weeks because she's pregnant.
And where were you working in demolition?
In Illinois, it's pretty much everywhere, but
Where are you
that's what
based out
I
of?
asked you if I can work out of county.
Where are you based out of?
In the work site is in Harlingen.
Yeah, depending on how you behave, that will be granted. If you start misbehaving, I will take it away and you will stay in Cameron County. I don't want to do that, but I want to trust that even when you're in Illinois or wherever you're at, you're going to behave, because if you don't, you get picked up, they'll notify me and I'll bring you right back and I'll sentence you to prison. Do you understand that?
Yeah.
The fact that you're not here in this county does not eliminate your conditions of probation. You are to observe them anywhere you're at.
Yes, sir.
All right.
GED or high school diploma,
You have it, Mr. Quiroz?
I'm working on that.
He's working on it. Yeah.
and if may I have a phone number, please?
956-660-0664.
660.
660-0664.
Thank you.
All right. And he'll be allowed to travel once he makes the original appearance here to get everything set up. All
I'll
right.
note that down, Your Honor.
If
Thank
he's
you.
working and his job requires for him to go out of town, we'll ask the probation officer to allow him to do it.
Yes, Your Honor.
The court will give 108 days to pay the court cost. Anything else? Mr.
On our part, that's all.
Mr. Sorolla, don't leave right away. Let everybody else leave the screen here. You can go, Mr. Quiroz.
All right, thank you, sir.
Thank you.
And as well, Ms. Garza. Okay.
Judge, I believe that's all I have. May I be excused?
Thank you, Ms. Aranda. Another great performance. Thank you.
Thank you, Judge.
May I be excused, Your Honor?
Yes, sir.
Good day, everyone.
You too. Mr. Sorolla, did you have a brain moment there when you told me that you had not delivered the plea papers and that you needed more time, or what?
Yes, Judge. What happened is I took them to your court and I didn't have them with me. So I didn't know where they were, but then I remembered I had taken them to your court, Judge.
All right.
Okay. 61 years old.
Well, come on, Mr. Sorolla, don't give up on me, man.
I'm not. I actually did good, Judge. I took them to the court, but I had just forgotten and I didn't see them this morning. I didn't put a note dropped off at court. Sorry.